very good morning to all of you present here. Today we have a guest named Professor G.B. Reddy. Professor G.B. Reddy is a professor of law at the University, the Osmania University, Hyderabad. Earlier, he was serving as a professor of law in the University Law College, Hyderabad. He is the chair professor at present, and the chair professor is the founder chair professor of intellectual property rights at the Osmania University, Hyderabad. He has taught, read extensively, published research articles, and he has almost written 23 books. All of them are very right, and as many as 70+ articles in the area of research. It may be in the area of intellectual property rights, it may be in the area of election law, or it may be in the area of women in the law. Just to bring it to your attention, he is the first one to write a book on women in the law. It was almost in the year 2000. And of course, he did not stop and started a number of publishing wonderful research articles like that. In addition to this, he is a visiting faculty at various places. And he is a visiting faculty at the Academy of Police Sciences, Hyderabad. It is a police academy generally called National Academy. And he is a visiting professor at the Nalsar University, and at the Judicial Academy, and at the Resource Development, EDC, Resource Development Center at the Osmania University, Hyderabad. These are a few things which I have just mentioned to you about Professor G.B. Reddy. Many other things. When we approached him, he has readily agreed, and he just pointed out, if you permit me, I will be welcome to speak on the art of writing research articles, how it is being written. As most of you are young, you should know how articles are being written. Before articles are written, you should be in a position to know equally very well how material is being collected and how the data is being classified and what is required and what should be ignored. These are a few things which are part of research methodology, and Professor Reddy will be in a position to speak extensively on this subject. With this, once again, on behalf of the Board of Management, on behalf of the Chairman and the Chancellor of the University and the Vice Chancellor, and especially the School of Legal Studies, CMR, and on behalf of all of you, I welcome you, sir, for this function. I request Professor Praneshwaran, the Director of the Law School, present educate as a token of our love and respect. I also welcome all the learned participants who have registered for the course, and most of them are online, in the online mode, and great welcome to you all. I also welcome all the CMR University Law School teachers present here, and everyone, and wish you the best of luck to them.
Thank you, sir. I now kindly call upon Professor Dr. G.B. Reddy, a Professor of Law and Chair Professor at the Osmania University, Hyderabad, to address the gathering and begin with our first show for today.
Very good morning to all of you. Professor P.R. Osmania, Dean, School of Law, CMR University. Professor Praneshwaran, Director. All the learned faculty members of CMR Law School. The research scholars, the other respected resource persons, and participants. I'm very happy to be part of the national seminar on legal research methodology organized by the prestigious CMR University Law School. I must thank Professor Subramania for inviting me here. I remember my last visit few years back when I was asked to speak on public interest litigation. And one thing comes to my mind when CMR school name is mentioned. The phenomenal rise in terms of the number of publications, the publication of journals in UGC case list, and the number of academic and other programs which are continuously organized, which are going to empower the young mind. Well, there is a saying in the context of intellectual property rights, patents are perishing. There is equally popular saying in academics, publish or perish. If we don't publish, nobody would notice us. Good or bad, we have to make a beginning. And it is through our publication that we get noticed, we give inputs to the stakeholders like the lawmakers, the other researchers, and we make a permanent contribution in the form of the articles, monographs, books, reports, or by whatever name they are called, which will help the coming generation, which will help us in understanding the contemporary development. Small example. We are not living in isolation. We are all social animals. We are not living in silos. What is happening the next door will definitely have an impact on what's going to happen in our case. Small example is, take the case of Roe versus Wade. I think all of you are aware. For almost 50 years, the moment somebody said right to privacy, we mentioned Roe versus Wade. Supreme Court also mentioned. Whether it is Sarita versus Venkat Subaya, or, K.S. Puttaswamy and many other leading judgments. Fine. Then comes the judgment in May of the same American Federal Supreme Court, which overturned Roe versus Wade by 8-1. Sam Alito has become a punching bag. He is the judge who delivered the majority judgment. And here we are in India. We are talking about right to privacy. We are talking about right to privacy of the body, the reproductive rights. And in the recent judgment, about 2 months back, it was given, the Supreme Court says, X versus Secretary, the Department of Science, Health, etc., Women Welfare, that even an unmarried woman has right to privacy in respect of her body. That was the case under MTP, Medical Termination of Pregnancy Act. What I'm trying to say is that these two developments which took place in two different parts of the world, they have an interconnection. Certainly, you can compare and contrast. And you can also predict the future developments in this particular area. And what a fantastic contribution would it be if you come out with a comparison. You're talking about very advanced jurisprudence, humanitarian jurisprudence, human rights jurisprudence. Today is the Human Rights Day. And here comes a particular judgment, probably influenced by certain overtones which are not so germane. Now, many Americans are not happy with the judgment. But here comes India, which caught up late, but still we are going in the right direction of expanding the human rights jurisprudence, the jurisprudence relating to the whether it is feminist jurisprudence or any other jurisprudence. Therefore, publications are order of the day. Without publications, probably our purpose as teachers, researchers, even practitioners. Please look at the websites of many of the law firms. In Bangalore also, there are so many. Every law firm has a website. Every website has an article. Of course, it is like a snippet, maybe 1 page, 2 page, but most of them are contributed by our young researchers, young students, scholars, practicing advocates, for whom research is the lifeline. Well, I really wanted to make a kind of PowerPoint presentation, but I don't know. I don't think it's necessary also because sir called it the inaugural address. I have the liberty of touching upon number of issues. So therefore, PowerPoint presentation may not be necessary. Nonetheless, I would like to touch upon few important aspects relating to the contribution of original paper. And many people think that legal research is meant only for obtaining a PhD, only for the 3 fascinating words, PhD, LLD, so on and so forth. Is it the case? I don't think so. Certainly, we come across the purposes of the research multifold. As I already mentioned, even to write a judgment, one needs the assistance of researchers. I'll give you another live example. Recently, in a landmark judgment called Mohit Minerals, some of you must have gone through it. You talk about cooperative federalism. The Supreme Court was speaking about uncooperative federalism. Blend of cooperative and uncooperative federalism is a basic feature of the Constitution. That's what the Supreme Court said. And to arrive at that particular conclusion, the Supreme Court judges had to refer to an American publication, which is very well written on uncooperative federalism. This is the essence or purpose of publications, which are referred to throughout the world. Well, as I already said, the research is always critical to both social, economic, and even the cultural development of the society. Unless we conduct research, nothing could be done. Another important aspect is, when we are talking about research, we have to emphasize on read. We are going back again. We are going back in circles. Simply by looking at 10 different sources, collating them, coming out in the form of a publication is not research. I remember one of my good old colleagues who is in Lloyd's probably right now in somewhere near Delhi. She used to read at least 2 classical books, classic works on law during every summer, whether it is Anson's Law of Contract or, Cheshire on 5 foot and on thoughts, or White Collar Crimes by, yes, there are so many other classics. Then I used to ask, Madam, you already became a professor. You have a PhD. You are guiding PhD scholars. Why do you want to read? Once again, he says, I want to conduct a research now, sir. Because those days, we had to read only for a specific purpose. Now we have to look at the same in a critical fashion. Same is the case with jurisprudence. Jagdeep Dhankar, our Honorable Vice President, has been in the news recently, especially during the last 15 days. And he is leaving no stone unturned to say that the collegium system is bad. in striking down the 99th constitutional amendment in 2015, according to the learned constitutional lawyer, he was a lawyer before he became governor. He says that this is something unparalleled. He is entitled to his opinion. But here you have to look at two things. As a law teacher, a researcher, or law student, I look at the conflict between the precedent and legislation. Which will dilute what? Where do you find the answer? Go back to Solomon's jurisprudence. There are a number of passages on this. The conflict between the precedent, judicial precedent, the judgments given by the court, and the legislation passed by the competent legislature. This can be a fascinating research. You can have a look at, in fact, the number of constitutional amendments, the number of judgments which were diluted by the constitutional amendments. So right from 1950s till 2022, including Golaknath judgment, including Keshavananda Bharati, including many more. This is how we have to approach the subject from a critical perspective. This is equally important. Well, as I already said, research means going in circle, coming from the word chercha. And many scholars, they start with the words like, as we are very well aware, so and so is the proposition. Then where is the need of publication? If it is so obvious, if it is already known to the world, if it is already published, where is the question of mentioning as we are already aware? Where is the need of research? We have to find solutions to the existing problems. That's equally important. Therefore, only when we conduct original research, come out with original publications, we can find the necessary solutions. And look at Encyclopedia Britannica. There is a wonderful statement there. It says, without research, no authoritative works have been written, no scientific discoveries or inventions made, no theories of any value propounded. Research is critical for this purpose, not only in the scientific field, but also in the humanities, arts, social sciences, so on and so forth. This is one important aspect. Then, I think while talking about writing original research papers, we have to remember some of the basic rules of research. Many of the youngsters tend to forget. Maybe the senior teachers, professors, and scholars, they scrupulously follow these basic rules. But the youngsters who are in a hurry, not because they are incapable, they are equally competent, but they are always in a hurry. So they want to produce an article overnight. But in the process, the basic rules may be, in fact, ignored, or sometimes, they are deliberately kept aside. And for instance, if you look at Oatley BA, he wrote a wonderful article, which you will find in the publication of ILI, Indian Law Institute, on legal research methodology. S.K. Verma and Afzal Wani edited. This is one of the papers. And there he talks about some reflections on legal research. The first basic rule is that aim for sound, publishable research and not unattainable perfection. Aim for sound research, publishable research, which is capable of being published, not unattainable perfection. In legal research, there is no perfection. Let me tell you. We have a very eminent professor, author, jurist, Professor Ishwara Bhatt, probably is going to address you in the afternoon. Even sir can't say that this is the perfect research. He himself said that. It is not unattainable perfection because law keeps on changing. The dynamics of law keep on changing. Therefore, we must keep ourselves abreast of all the latest developments. At a given point of time, the research may be perfect. The next moment it may not be. We may be outdated. The second one is, what we need is dispassionate and honest investigation. Dispassionate and honest investigation. Sometime back, somebody approached me. Sir, I would like to conduct a research on domestic violence. Then I said, why? Why are you so particular? You are a man. Are you a victim of domestic violence? He says, no, sir. I am a victim of misuse of this particular act. Therefore, I want to conduct my research on domestic violence, PWDV Act 2005. You tell me, is he going to come out with a dispassionate finding with regard to this particular law? He already have a preconceived notion in his mind. The rule which we have to learn here is that we must have an open mind. We must be in a position to look at both the sides and come out with a dispassionate investigation and honest findings. It's not, something which we already decided, which we would like to justify in the form of this. Another one is, nowadays research is not confined only to books, articles. Everybody does it. I keep on saying the difference between a good teacher and a good student is, in the good old days, it used to be few hours. Today it is few minutes. Same laptop, same resources, whatever you are trying to say, they will try to cross-check. Maybe after 15 minutes, they know much more than what the teacher says the teacher knows. What I'm trying to say is that we have to look at the various sources of literature, information, not only the books, articles, statutes, but take the case of the experts, taking help from the experts. That's equally important. People talk about judicial self-restraint. Who should come to your mind if you have to contact a living judge who has given number of judgments on restraint? Justice Markandeya Kaju. Speak to him. Try to understand what made him, such a restraintivist. He's an expert. You can also go for an activist judge. What I'm trying to say is that today you have number of new kinds of research, including action research, wherein we have to, be in touch with the experts in the field. Then another important point is we should always have a plan around fine. Then we must be in close touch with the group of scholars working on the same topic. It is not something very secretive. When you are conducting research on a particular topic, writing a paper on a particular topic, there is absolutely nothing wrong in getting in touch with the others who are working in the same field. And there is a saying in Sanskrit, Partaya Vardate Vidya. If you go on deliberating, discussing, then the Vidya, the knowledge will be improved. Same is the case with regard to the research. Then another one is, we tend to give references even without going through them. This is another important point. You must have seen the youngsters, what they do when we ask them to give references. Simply they give a bibliography which can be prepared within few minutes by using software. But without going through that, unless we actually read, we cannot and we should not quote such references. Then copyright also must be respected. Nowadays, a new dimension is coming up. Please try to understand. It's not only the research scholars or the publishers who are accused of plagiarism and copyright infringement, including the lawyers. The lawyers, it seems, they are simply copying from the judgments and sometimes the pleadings which are produced by other lawyers in the courts. Simply by changing the names and few particulars, they are trying to submit the same before the various courts. That should not be the case. Well, the recent trends in the research, as far as legal research in India are concerned, as I already said, there is a fascination for acquiring 3 letters. After that, the research is put to an end. We have to remember that PhD is the beginning of research, not the end. The real research begins post PhD. Then, you have to come out with the original research more. Then another one is information technology is our savior. I'll give you a small example, live example. UGC has come out with the regulations on academic honesty in the year 2018, which are amended recently to include self-plagiarism also. Now, in LLM, I'm talking about my own university, not about other universities. We included 25% limit as far as the similarity index is concerned for LLM dissertations. And every dissertation will be put through Turnitin software. Only when the similarity index is less than 25, it will be accepted. Actually, in case of PhDs, it is 10%. That's a rule. But since it's the first time and it is only a dissertation, we thought 25 would be better. Believe it or not, almost 90% of the students, they don't want to follow these regulations. As if we have an option. We don't have an option. Then they came out with some ingenious methods, ingenious ways of overcoming this difficulty. How simply they are trying to join two words which make no sense. Right? And they add both the words with some letter which is in white color. To the naked eye, it doesn't appear. And it looks like a new word, therefore, our Turnitin anti-plagiarism software doesn't detect. First 10 pages are original. Remaining 60-70 pages are scanned copies. Scanned copies are not detected. Sometimes photos are kept, images. And ultimately they are saying, sir, one person came to me, 87% is the similarity index. I myself, subjected it. Then within 3 days, he came with 7%. Miracle. Then I said, we are aware of all these practices. The only purpose of insisting on original research is to equip you, to empower you. And when you spend so much time in bringing down the similarity index, you can also do that in making your thesis or dissertation original. Maybe it will take 1 or 2 hours more, maybe 1 day more. So this is the kind of, in fact, trend which we see in modern times or recent times. This is another important point. There is another one, commissioned syndrome, commissioned thesis syndrome, commissioned dissertation syndrome. When we are very strict about the similarity index, anti-plagiarism and all, they don't write, they get them written. Another important point, very unfortunate. And it happens in the case of even PhDs also. In the good old days, there used to be a saying, to go to Delhi empty-handed, come back with a thesis. So they used to submit within next, 4 weeks, 6 weeks. They used to bring some thesis from Jawaharlal Nehru University or ILI or the Delhi University. Fine, you make some changes here and there, then produce. But those days, there was no Turnitin. Today, it's not the case. Everything is, in fact, chronicled and recorded. Let's have a, look at some of the do's and don'ts for effective legal research. First, let's have a look at the do's. Very first one is originality of an idea. This is important. Our idea must be original. If it is already a beaten track, if already 1,000 PhD theses are produced, then, for example, sometime back, I was in IPPI University in a research board. A presentation was made by one of the scholars, and very bright scholar. I don't want to condemn her. Her topic is e-waste management. And then I typed the e-waste management in the Google. I could get few lakhs of entries within few seconds. Then I said, madam, what just where e-waste management has lakhs of entries? What is the thing you are going to do originally? What is the original idea? So ultimately, we changed the title, we changed the scope of our study, we made it empirical, right? And we have chosen about 5 or 6 institutions. Then she's supposed to conduct research, supply questionnaire, go for interviews. Then ultimately, I think it is at the fag end of her research. What I'm trying to say is that if the idea is not original, you don't expect any original research work also, including publication. The second one is originality of expression. It's not only that idea must be original, expression also must be original. The basis of copyright protection, is it not? Expression must be original. And if we are going to follow X, Y, Z, some pattern which is already in place, then it will not be original research. The flexibility and affordability, this is also equally important. When we want to write research papers, choose a topic on which there is good literature, not abundant literature. Take a very small topic, a micro topic, right? Then try to, in fact, expand, conduct extensive research into it. We can't simply, in fact, take a topic which is too broad, in respect of which there are too many publications, too many works, and say that, no, my topic is original. Another one is the manageability of and the capability of data analysis. How much data is available? How much can it be, collated? How much can be produced? How much can be analyzed, synthesized? That is also equally important. If it is unmanageable, we can't come out with original research papers. Another one is compare and contrast. Here also, I'll tell you a joke. One of my good colleagues always says, in every PhD thesis, one chapter should be a comparative study of UK and USA. Why only UK and USA? Are there no other countries? Are there no other legal systems? If you want to talk about ombudsman system, probably you go to Scandinavian countries, make some comparative study, right? If you want to talk about the protection of seats, Canadian courts have developed a lot of jurisprudence. There are a number of laws. So what is comparable is important, not just because, it is UK and USA. That's because comparability also must be ascertained. Another one is throw light on the contemporary developments. If we can't live in the past is equally important. Come out with historical perspective. Few lines. Right to privacy, yes. But if anyone is writing something on right to privacy without referring to the joint article written by Louis Brandeis and Samuel Warren in 1890 in Harvard Law Review, his thesis will be incomplete. His publication will be incomplete. Today you talk about right to be left alone, right to be forgotten. These are the new development, new dimensions of right to privacy. But when you are going back to origins, every person's home is a castle. Where do you come across this statement? Go back. So the originality comes even when you refer to the evolution. This is another point. Then be uniform in citation. This is another important point. I'll tell you. As research scholars, we also committed these mistakes. Suppose I am quoting same Keshavananda Bharati versus State of Kerala. DPIIR 1973, Supreme Court, 1471 or something like that. Maybe 1471. On page 1, I give AIR citation. AIR is All India Reporter. On page 3, I give Supreme Court cases citation. On page 10, I give SCR, Supreme Court reports. Where is the uniformity, please? Because the head notes differ. Sometimes the paragraphs may differ, especially when 13 judges are giving a judgment. 7 per majority, 6 per minority, separate but concurrent judgment. If there is no uniformity in citation, of course, with regard to the citation, today you have Harvard Blue Book, we have OSCOLA, we have ILI mode of citation, we have MLA Handbook, Modern Languages Association. There is no hard and fast rule. Your methodology, your method of citations must follow the citation suggested by the publisher, suggested by the university, not our own. If the university says don't give endnotes, right? Or don't give footnotes, or you follow only this kind of methodology, fine, we have to follow that. And this is equally important because whether it is Harvard Blue Book, 20th edition, or the Oscola is followed now extensively by many of the, in fact, national law schools also, or Indian Law Institute, style of citations. That is also equally good. But we must be uniform in citations. Then another important point is we have to come out with original findings. There must be a purpose of publication, not to, give vent to our feelings. Come out with suggestions, come out with original findings. And how many findings are made? Hypotheses are 3, findings are 30. Sometimes you come across this kind of scenario. When you frame the 3 hypotheses, based on which you continued your study, you try to test the veracity of those statements, tentative statements called hypothesis. Fine. But your findings must be in respect of those hypotheses. Maybe 1 or 2 extra. Then suggestions. How many suggestions? People come out with tens and hundreds of suggestions, which are totally irrelevant. Let me tell you. If you are a legal scholar, we expect law suggestions, suggestions in law, legal suggestions, then suggestions to administrators, suggestion to police, suggestion to voluntary organizations, suggestions to citizens. What is it? Is it a series of suggestions? Suggestions based on the findings of the study, but they must be manageable. They must be few. They must be practical. That is also equally important. Then that is the next point. In fact, come out with practical suggestions. Come out with practical suggestions. See, collegium system. I'll give you another example. I'll go back to the same example again. Collegium system, if somebody wants to conduct research on the working of collegium system in appointment of judges of higher judiciary in India, is everything closed? Is there anything new? Recently, you must have seen. An outgoing Chief Justice wants to conduct a meeting of the collegium within few weeks before he demits office. I'm not intending any, kind of blame. The point is, then the question is about the convention. Within how many days the meeting should be conducted? How many days before the Chief Justice retires? Then whether the suggestions or recommendations made by such collegium are binding. Today you see the newspapers. It's about the RTI. Under the Right to Information Act, only the final resolutions of the collegium are accessible, not the deliberations kind of thing. Means there is something left, even in this much beaten track, to be researched. That's what we have to look at. Another important point is, when we are talking about, of course, there are also don'ts, not only do's, but don'ts. Don'ts are more important. Originality and plagiarism. I think already there is one session on that. I will not go into that. But academic honesty and integrity is equally important. Simply because sometimes it so happens that we come across some great work published in 1910, which is in a dilapidated condition, which has, wonderful, in fact, information, insights, principles, doctrines. And we don't even know whether the author is alive, whether the publisher is still retaining copyright or not. Can we simply go on, in fact, incorporating those provisions? Probably will not. The point is, plagiarism is immoral mostly, and we must avoid. And there are instances of vice chancellors of central universities being forced to resign for plagiarism. I don't want to name. They are all our, fraternity. But when Professor Madhav Menon's works were copied verbatim and claimed by someone as if they are her own, and ultimately when she claimed 22 papers as her own publications, but it was hardly 1 or 2 publications, then she was made to resign. Name is not necessary. University I can give you, Pondicherry Central University. That happened in the field of law. There are many chancellors also, vice chancellors, and many more, in fact, persons in very high position who were accused of plagiarism and who had to lose everything. Even youngsters like Kavya Vishwanathan. Kavya Vishwanathan, when she wrote a novel called How, Opal Mehta got seduced, etc., etc. It was found that she liberally copied from two adult novels written by Megan McCafferty. It is there in Google. You can see Wikipedia also. You will find which portion was taken and which portion is not there. We must avoid. Of course, we have a very beautiful excuse in the form of paraphrasing. Paraphrasing. Research consists of only three things, honestly speaking. One is summary. The second one is paraphrasing. Third one is quotation. You remove these three things from anybody's research work, then you will know how original it is. We have to paraphrase. Everything doesn't come from our mind. But we must paraphrase in such a manner so as not to lose track of the original credentials, the original author's details. You can refer to him or her, doesn't matter. But we must paraphrase, and that too, maybe one paragraph, fine. Entire book cannot be paraphrased. Our PC or laptop is, better equipped to paraphrase. I think you have number of softwares now, Zotero and many others. And you can upload about 120 words or 165 words, depending on the software. Within no time, you have a paraphrased version. Only problem is that it will not have any meaning, neither beginning nor end. You don't have control over it. We can escape from similarity index check, but we can't escape from the scrutiny of the other reader, the peer, the professor, and many others. This is one. Now let's come to don'ts. As I already said, don't commit plagiarism. And let me tell you, the amount of effort taken to write original paper will be almost the same with regard to plagiarize somebody's work. Only thing is a few hours of difference. We can as well use the time for, coming out with our original work. This is one. Quotations. Don't quote extensively. This is another one. Are judgments copyrightable? Judgments of the Supreme Court, judgments of the High Court, they are not copyrightable. Section 52 also is very clear under the Copyright Act, 1957. So what the people do, one of our old students was doing PhD on the right to development of the tribals, and she asked for a good case law on that. Then I suggested Samatha versus State of AP, Justice K. Ramaswamy judgment. Believe it or not, she produced half of the judgment in the thesis. And very fortunately, nobody detected it. She got PhD also. Because Justice K. Ramaswamy did wonderful research while writing that judgment. And what she did was not illegal, but immoral. Please try to understand. We have to avoid both, not only the illegal things, but also immoral things. And don't be careless in paraphrasing. This is also equally important. Okay, I will change. Instead of looking, you say seeing. Right? This can be done by even our own children. School-going kids also will do that. Will be easily caught. So paraphrasing must be like, we are reading 2 or 3 paragraphs, reading a page, reading an article. We are trying to analyze, synthesize, and reproduce in our own language, briefly. That is equally important. Quotations also must be brief. Quotations can't go for, in fact, pages together. Turnitin software doesn't detect anything which is kept in quotes, double quotes. So many people are keeping everything in within double quotes, so that, it doesn't detect. I think even Turnitin people are also They came to know about it. Now they are trying to change the pattern of checking the similarity index. Another point, fair use is only an exception with regard to copyrighted material. You can't say that, yes, for academic purpose, for research purpose, for reporting of current events, section 52 is our savior. Therefore, it will not amount to infringement of copyright. Two things, plagiarism. Plagiarism means kidnapping. Kidnapping somebody's material and claiming that it is our own. Copyright, it is a statutory infringement. Fine. But at the same time, we have to make selective use of the fair use doctrine. For everything, fair use will not come to our rescue. That's another point. Then don't underestimate the examiner. Don't underestimate the reviewer. When Professor Subramania sir gives a call for papers to be published in 3 of the journals, I'm sure that he will be sending them for peer review, blind peer review. And especially the experts in that particular field, depending on their specialization, their publications, they are carefully chosen. Now, if it is constitutional jurisprudence, it may go to somebody like Professor Bhatt. The point is, he knows what is the publication, what is the list of publications in that particular area. What are the leading cases? What are the articles? What are the books? Suppose somebody copies from those, very easily it can be pointed out. Don't underestimate the reviewer. Don't underestimate the supervisor. Don't underestimate the examiner, because they will be sent for examination. Please try to understand that. Then another important point is, don't ignore the UGC regulations. Because normally, all these years we thought that the supervisors are not responsible, the concerned university is not responsible, only the contributors are responsible. That's not the case anymore. Today, I think the supervisors will be made liable. They will be punished when they certify any particular work as original work. If it is in clear violation of the UGC regulations on academic honesty 2018, then certainly there will be punishment, there will be sanctions. Another one also, we must be very careful. Recently, I gave a call for papers for our blog. Somebody published, submitted a good paper. But when I submitted it through this Turnitin software, nearly 70 plus is the similarity index. And the funny thing is that he copied from one of his own journals, own publications, which was published before. What do you call it? Self-plagiarism. This is the most important thing which the research scholars and others must remember. We should not indulge in self-plagiarism. That is also plagiarism, and that is the latest amendment to the UGC regulations of 2018. The same penalties will follow. Then some of the useful tips that can be given by anyone in coming out with 5 minutes. First point is this: analyze and synthesize. Don't just paraphrase. This is equally important. You look at the controversy relating to, is it law of thought or law of thoughts? People have written pages and pages together only with regard to that yes. So that is the kind of debate which must be generated. So simply reproducing will not attract such scholarly debates. Second one is, we must avoid sweeping generalizations while writing research papers. Sweeping generalizations, that is, for example, you see, all the Babus are corrupt. Generalization. How do you know that all of them are corrupt? Right? All the judges are, they encourage psychophancy. Some people might do that. So we have to avoid sweeping generalizations. This is important. Then avoid the obvious. I already mentioned that. This is from my own personal experience, friends. I submitted an article to Australian Journal of Comparative Law. Within 20 days came the reply. Your article is not accepted for publication. So being a teacher, being a little egoistic, I wrote to the concerned person, Madam, I would like to know why it is rejected. This is about 15 years back, not now. Then she gave a list because you see, you wrote in the Indian context, but you want the publication to be made in Australia. And our readers, they are Australia, and they go beyond Australia also. So simply you talk about some of the words which are typical, are unique only to India. How can you expect others to know those? And similarly, you are saying, obviously, as is well known, as everyone is aware. How do you know that everyone is aware? Another point is, if it is so obvious, what is your contribution? Is it not? If it is not obvious, then only we can do something on our own. If it is obvious, what is our original contribution? This is another important point. So, clearly, simply, obviously, so on and so forth should be avoided. The point is, if your point which you have made is really that obvious, then why waste the time and space restating it? Is it not? Give it in the footnote and forget. Then another important point. This is one common mistake committed by many, in fact, authors. Several authors have opined that, but there is no footnote under the several authors. If there are several authors, you mention at least a few. That's important. Several, many. So therefore, we have to identify, in fact, at least few of the authors, few of the sources, numerous reports. You are talking about competition law. So you have to look at Vyas committee, you have to look at the other committee, whatever it is. But several reports, you mention at least few of them. This is another one. Then don't apologize for your positions. This is equally important. Sometimes we take a particular stand, then we apologize. Very unfortunately, why should you be, saying that it is unfortunate? And don't be opinionated. I think in the opinion of the author, who wants your opinion? They want your finding. They want your suggestion. They don't want your opinion. There are so many people in India who can give their opinion, right? This must be avoided. Then similarly, we must avoid making broad statements like doing X, Y, Z is illegal. Unless we are sure about, no question of saying that so and so is illegal or legal. How do we know? How do we cross check? All the live-in relationships are illegal. Can we say that now? We can't say. There are, different opinions, and Domestic Violence Act recognizes some such relationship also in the nature of domestic relationship. This is another important point. We have to cite primary sources. That is another important point. We have primary sources and secondary sources. Many people cite secondary sources when the primary sources are very much available, accessible. So we have to cite the primary sources. Suppose you want to cite the Constitution of India, cite some legal provision, cite some precedent, then why should you look for the analysis of that precedent published in XYZ journal? You can refer to the precedent yourself. This is equally important. And this is the precise reason why the emphasis is shifting to empirical research nowadays. At least there is some kind of originality. The findings of the research can be easily, in fact, chronicled, recorded, and analyzed. Then avoid gratuitous comments. This is also another important aspect. Sometimes in our flow to write more and more papers, we use the, in fact, expressions like we should not forget that. Why? Why we should forget or we should not forget? These things must be avoided as far as possible, and keep the tone serious. That is important. Coherence is important. When you have a strategy for writing a research paper, you have a blueprint, you have a synopsis. And right from the beginning till the end, what you are going to write. Yesterday, I was discussing with, again, our Professor Ishwar Bhatt sir, while coming from, in fact, airport to the place. I don't want to name the book and all. We were discussing about a proposed book on something related to constitution. And sir was so clear. He's saying that, okay, there are 25 or 26 chapters, out of which 13 are over. I am going to discuss these things. This ism, that ism, this doctrine, this principle, this interpretation. Means only when the author is very clear about the blueprint, the research papers will not come out. They will be stuck. One of my students, colleagues, conducted research on intellectual property rights. He was waiting for the perfect moment to complete the intellectual property rights protection in India and TRIPS complaints. So international law professor is here, Professor Subramanya sir. Now the TRIPS agreement was in 1994. India complied with TRIPS agreement substantially by 2000. With regard to product patent, 2005. My friend got registered for PhD sometime in 1996. He completed in 2016. Point is, where is the perfection? Now, the point is over. In 2005, total compliance has been ensured. Now you have to talk about TRIPS plus protection. Not TRIPS protection, but TRIPS plus protection, TPP. Those scholars in intellectual property rights. Now you think about the possibility and the desirability of giving TRIPS plus protection as is made out in many of the free trade agreements which are proposed between UK, India and many other countries. That is where I think our original research comes out. And another important point is proofreading. Don't think that only, spelling and grammar check will take care of it. We have to read every word of it. There are going to be repetitions. We are not going to be aware of our own mistakes. So you proofread, get it proofread, and ultimately come out with, the rumor-free presentation. This is another one. About copyright infringement, I don't want to say much. Plagiarism, we must avoid. I already mentioned. Instances of plagiarism can be seen even in the case of vice chancellors. And I can give you the name of another vice chancellor, not from law. One Professor Rajput. He was the VC of Humayun University. And himself and his colleagues, they specialized in theoretical physics. But what they did was simply they copied a peer-reviewed article in Stanford University Scientists in Physical Review and published in India. Are we not aware? If we are going to plagiarize, same thing will happen, whatever happened in the case of turmeric patent in USA. Remember, turmeric patent, it was almost granted, not to the Americans, only to the Indians, 2 Indians who applied for turmeric as a patent, as a kind of, in fact, antibiotic agent, right? And what the Indians thought that since in India everybody knows about the uses of turmeric, in America they may not be knowing, therefore we will get the patent because it will be novel. Did it happen? Ultimately, the USPTO, in fact, rejected the claims on the ground that novelty means novelty everywhere. Not only in India, not only in USA. Your paper also must be novel and original everywhere. That's what I'm trying to say. If it is already known, already published, then nothing could be done. So there are a number of issues which can be discussed. I don't want to, exceed my time. I think already 1 hour is over. To conclude, I would say only this much. Remember the statement I made in the beginning. Publish or perish. Please publish. Second, provided your preparation is good, your understanding of the subject, the core subjects is good. Don't ignore the core subjects. You may want to do something in competition law, nothing wrong in it. You want to write something in insolvency and bankruptcy code, go ahead. At the same time, don't forget the concept of insolvency before writing on IBC. Don't forget the concept of monopolies and restrictive trade practices or antitrust, right? In the case of the core area, right? When we are talking about e-commerce and protection of rights of the consumers in e-commerce, but first you be aware of, be thorough with the rights of the consumers under 2019 Act or maybe 1986 Act, whatever. So be sound in your fundamentals. This is important. And that is the precise reason why we must refer to standard literature, standard publication. And don't think that the latest publications are the standard. You go back to the basics, go back to the roots. That's another important point. Then compare and contrast wherever it is possible. Take a small area, micro area, then expand it. Don't take a big area and mess up with your publication. Take a very small area, minuscule area. For example, domestic violence in the families of IT professionals in Hyderabad, a critical study. Why? Because it is reported that in IT families, where both the spouses work in the IT industry, one in accordance with the American shift and another with the Indian shift, there are a lot of instances of domestic violence, and that too in Hyderabad, that too in high-tech area, high-tech city area, that too where a special court is established. Try to work on that. Then interdisciplinary approach should not be forgotten. Multidisciplinary legal research shall not be forgotten. People are talking about, okay, now marriageable age must be increased to 21 years, even in case of girls as per the proposal of Union government. But don't make only the legal study, also make a kind of psychological study, scientific study, the hormones, the physiological factors. Take the case of Juvenile Justice Act. Why a child between 16 and 18 years can be tried as an adult in certain cases for serious offenses. You make a scientific study there. Don't look at only the age, the 2 years difference. What happens, right? The release of hormones, the kind of psychology of the children in that particular age group, very small area. Then I think our publications will be original. I thank all of you for giving a patient hearing. I thank Professor Subramanian sir, Professor Praneshwaran, and other colleagues for giving a very patient hearing and a wonderful platform. And thank you, Vanessa. Thank you very much.